This is recording number 2 in theme 1 of interpretation of statutes. And what we've done so far is we've looked at what is the law and why does it sometimes need to be interpreted. So now we have to look at what is interpretation. It's about making sense of the act as part of the legislative scheme, and it has certain rules to assist. It's not a mechanical exercise. It's not a computer. You feed something in on one end and you get a result out, a predetermined result out on the other end. It's a bit of an art, and it's been very well described in the British case of Corocraft versus Pan American Airways. I'm going to read this quote to you because it's important and you're going to have to remember it at some point, is my guess. In the performance of this duty, the judges said, the judges do not act as computers into which are fed the statutes and the rules for the construction of statutes, and from which issue forth the mathematically correct answer. The interpretation of statutes is a craft as much as a science, and the judges, as craftsmen, select and apply the appropriate rules as the tools of their trade. They are not legislators, but finishers, refiners, polishers of legislation, which comes to them in a state requiring varying degrees of further processing. So that is what interpretation is. I'm going to make the slides a bit bigger. I think it's easier to see them. So what was the impact of the Constitution on the interpretation of statutes? I'm going to refer you to the relevant sections very briefly, and your campus lecturers will fill in the blanks. So the Constitution is the supreme law of South Africa. That means that is the ultimate authority. That is what regulates the way in which our society functions. Any law or conduct which is inconsistent with the Constitution is invalid. So any legislation which does not uphold constitutional values will also be invalid. And what are our constitutional values? Humanity, the achievement of equality, the advancement of human rights and freedoms, non-racialism, non-sexism, and the rule of law, and the right for everybody to vote. There are certain obligations that are created by the Constitution. You will find those in Section 7. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. And the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. There's an application clause which tells us that the Bill of Rights, that is Chapter 2 of the Constitution, applies to all law. It binds even the legislature, the executive, and also the judiciary and all organs of state. Section 36 is our limitations clause. And that means that those rights which are ensconced in Chapter 2 of the Constitution, the Bill of Rights, can sometimes be limited. Only if it's done in terms of a law of general application to the extent that the limitation is reasonable and justifiable. So what I want to use here as an example is the National Disaster Act and all the regulations that go with it. So on the 23rd of March this year, the President announced a national state of disaster, and this started with a level 5 hard lockdown. Between then and now, in excess of 60 regulations have been promulgated in terms of this act, and it has limited our rights considerably. Think of the right to freedom of movement. Your right to freedom of movement has been limited because initially in the first phase, level 5 hard lockdown, you were not allowed to go anywhere unless you went to buy food or you went to a doctor, unless you were an essential services worker. So that has been relaxed a little bit, but our freedom of movement is still limited. For instance, there's still a curfew in place, certainly at the time when I record this lecture, that runs from 10 o'clock at night until I think it's 5 o'clock in the morning. I'm never out that early. Not entirely sure what time you're allowed to start moving again. That's a limitation of our freedom of movement. And the only reason why it is allowed is because it applies to everybody. It doesn't only apply to people who are 50 and older. It doesn't only apply to people who live in certain areas. It applies to everybody equally. So that is what makes it a constitutional limitation of our right to freedom of movement. So it's an illustration of how the limitations in Section 36 would apply. There's an interpretation clause in Section 39, and that simply tells us that we can look at international law and we may consider foreign law when we interpret the legislation. The next thing we need to look at is categories. So we take legislation and we place it into categories in order to organize it and also to attach importance to it. The first way in which we categorize legislation is chronological. So anything before 1806 is the oldest kind of legislation. Much of that has been abrogated by disuse. After that comes old order legislation, which is divided into two separate categories. The pre-union legislation, which runs from 1806 to 1910, and then the legislation between the formation of the Union in 1910 and the constitutional democratic era, which started in 1994. Then all legislation after 1994 is legislation under the new constitutional order. We also, sorry, let me just go back to that. I just want to go back to the hierarchy of legislation. So there you can see that it's divided into sections in the order of importance, Constitution being supreme and therefore the most important piece of legislation. Then comes all different forms of what we call original legislation. So those are acts of parliament. Provincial parliaments can make acts. Then there are the provincial ordinances and the legislation of the former homelands, TBVC states, and that some of that is still in force unless it's been repealed or replaced. And then there's municipal legislation. So the city where you live has a mayor and it has a city council, and they may make rules for how things are conducted in the city that you live in. So I'm in Cape Town, and for instance, there's a bylaw, that's what we call the rules that are made by the municipalities. There's a bylaw that says that we're not allowed to use alcohol on the beach. That's a form of original legislation, but the lowest in the hierarchy of original legislation. So acts of parliament would bind everybody in the entire country. Provincial acts would bind only people in the province where it was promulgated, and then the municipal legislation, the bylaws, will only bind the people in the municipal area where it was passed. Then we get subordinate legislation, and those are the regulations that are promulgated in terms of legislation, of acts. So you'll remember earlier on I said that there were about 60 regulations promulgated under the National Disaster Act. So a lot of those have been attacked as unconstitutional, and we'll come back to that later on in the course. But all those rules that you hear and that changes every week is part of the regulations that are made underneath the National Act. So the National Act regulates that the minister may make regulations, and those are the rules by which we live typically. Let's quickly look at what an act looks like. I'm going to go back to the bigger slide. So there you've got the Disaster Management Act, 57 of 2002. That is the act in terms of which we have a national disaster at the moment. And right on top there where the arrow is pointing, you've got the title of the act, the name and the number. And the number is Act number 57 of 2002. That's the 57th Act that was passed by Parliament in 2002. You have the date that it was sent to, and there's an arrow that shows you that. You have a date of commencement, there it is there. And there you'll see that some of the sections commenced later than others, over there, and you'll see a list of amendments of legislation that's been amended by this legislation. Then if we move on to the next picture, there should be a list of regulations. This particular act hasn't been updated, so we don't have that list there. We have a long title. We have an enacting provision without an enacting provision. So the long title, that's your list of regulations, that's your long title. There's your enacting provision. And in longer acts, we typically have a table of contents that just helps us to find what we're looking for much quicker. Right, then in section 1, we normally find definitions, and they serve as an interpretation aid. There you can see there. Right, I'm going to stop here again and pick up in a moment in a new recording.